Hello and welcome back viewers to another module of Economics and Law Part 1. Today we are going to discuss the holdout problem and its implications for the eminent domain. Let us start by understanding the meaning of the term eminent domain. The term eminent domain was first used by the Dutch jurist Hugo Grotius, who defined it as if the property of subjects is under the eminent domain of the state or he who acts for it may use and even alienate and destroy such property, not only in the case of extreme necessity, in which even private persons have a right over the property of others, but for ends of public utility, to which ends those who founded civil society must be supposed to have intended that private ends should give way. But it is to be added that when this is done, the state is bound to make up the loss to those who lose their property. In other words, the power of the government to acquire private land for public purpose upon payment of compensation is commonly known as the doctrine of eminent domain. Almost all modern democracies contain this doctrine, sometimes found in the republic's constitution and at other times in legislation. What qualifies as public purpose? The primary justification for the acquisition for private property, however, varies from country to country. While the union and the state governments in India continue to face significant challenges in procuring land for infrastructure projects, the individuals whose land they intend to acquire have been engaging in violent fights. The May 2011 Bhatta Parosil incident is just one of the several incidents where there were violent clashes between the villagers whose land was to be acquired and the police forces. One key issue in this context is the government's acquisition of property from one set of private owners in the name of economic development, followed by the transfer of that land to another set of private owners to carry out the economic development for which the land was obtained. Let's assume that the government seizes a farmer's property and then transfers it to a firm X for the establishment of an industrial facility or manufacturing unit, all in pursuit of economic growth. It makes sense that the government has scrutinized X's claims and believes that granting X the title to the farmer's land will optimize its use. It might also happen that Corporation X is in the middle of a huge project and the government has become convinced that the project is crucial to the economic development of the area. X requires a large land mass in order for the project to start, and the farmer's land happens to fall in the area that X needs for its project. A total of 10 people own that entire mass of land. So, X approaches all 10 individuals to buy their lands. Let us assume that 9 farmers agree to sell, but one farmer, Z, declines. This would be problematic because X needs to assemble all the land. And if Z refuses to sell, their project is dead before it can begin. Why did Z decline? Perhaps Z realizes how important this particular plot of land is for X and thus decided to extract as much money as he can from X. Now this is a problem for X because the farmer could potentially extract so much money from them that the entire project might lose its economic sensibility. Another reason for refusal could be that the farmer has a special emotional attachment to his plot of land and thus does not wish to sell. It is also possible that the farmer has studied the economic merit of X's project himself and is convinced that the land would be better used in his hands than in those of the private corporation. Regardless of the cause, the project ultimately ends without a land sale, leading to X's departure. However, the government does not want this since it is convinced of the economic merit of the project, and thus it exercises its eminent domain powers, acquires the farmer's land and hands it over to X. Therefore, the government acts as a middleman who transfers property from one set of private hands to another. We will now be discussing the doctrine of eminent domain and public purpose. The doctrine of eminent domain as it exists in India has a close equivalent in the United States, and what is happening in India appears to be a reflection of the USA and its early days. Old US rulings reveal that in some states the Supreme Courts used a stronger meaning of the word public purpose according to whether the public purpose was used by all or a portion of society. Other Supreme Courts, on the other hand, interpreted public use broadly, making it equivalent to unambiguous public benefit or gain. In context of India, specifically to the context of the Land Acquisition Act 1894, it has been noted that the public purpose should be specified ex ante rather than leave acquisition acts open to challenge, as is the case in the US. The current option of not specifying the public purpose and not allowing challenge in India has been criticized as most undemocratic, giving excessive discretionary powers to the government of the day. The 2013 Act states that its rules on rehabilitation and resettlement would apply when a private company requests the appropriate government for the acquisition of a part of an area so prescribed for a public purpose. The defining section of the 2013 Act provides a broad definition of public purpose. A social impact assessment must precede land acquisition, except in cases of urgency. Multi-cropped lands are similarly exempt from acquisition unless under extraordinary circumstances as a demonstrable final resort. The 2013 Act similarly protects land belonging to scheduled caste and scheduled tribes against acquisition except in cases of a demonstrable last resort. The 2013 Act exempts a total of 13 laws from their applicability. However, if the Union government provides a notification within 1 year of the 2013 Act's start, the compensation mechanism from the 2013 Act will apply to these 13 legislations either fully or with amendments. The Land Acquisition, Rehabilitation and Resettlement Amendment, Second Ordinance of 2015, not only excludes the 13 legislations in the 2013 Act from its application but also introduces further exemptions. In public interest, any project vital to national security, including preparation of defense or defense production, infrastructure in rural areas including electricity, affordable apartments and habitat for economically disadvantaged people, business corridors set up by either the union or state governments and their commitments going up to 1 kilometer on both sides of selected railway tracks or roads for such industrial corridors, and infrastructure projects, including projects under public. Now, what is the meaning of the holdout problem? The holdout problem refers to a type of monopolistic power that might arise during land assembly. Once assembly begins, individual owners, knowing that their property is critical to the project's completion, might demand prices higher than their opportunity cost. As a result, large-scale projects that need assembly, such as housing buildings or commercial malls, may incur significant negotiating costs. More significantly, developers of such projects will have an incentive to choose properties where ownership is less scattered, minimizing the need for assembling in the first place. Let us understand it better with the help of the same example. Now recall that farmer Z refused to sell the piece of land. This is known in the economic literature as the holdout problem. Whenever a huge mass of land is required for a project and the entire mass of land is owned by several people, the developer has to assemble the land by individually buying land from all the owners. In this case, any owner can potentially hold up the entire project, thus causing the holdout problem. In this situation, the government applies the doctrine of eminent domain, using its coercive power to acquire the land and eliminate the holdout. The government then transfers the land to the private entity that was holding up the project. Is it appropriate to permit this transfer? Should the government have the authority to seize the lands of one private entity, Farmer Z, and transfer them to the another private entity, Corporation X, on the grounds that the government believes that the latter can utilize the land more effectively? Does this truly qualify as public purpose, the avowed justification for the doctrine of eminent domain? Before we continue, it's important to note that this module has so far focused on holdout problem and eminent domain, which relates to situations where the government acquires land for economic development but transfers it to a private party to carry out the economic development using own private plans. The holdout problem occurs most frequently in large-scale development initiatives that necessitate the assembly of independently held pieces of land. When the assembly becomes public knowledge, individual owners realize they may impose significant cost on the developer by refusing to sell. Sellers gain a form of monopolistic power, allowing them to take rents from the developer, resulting in a delay or failure to complete the project entirely. In this context, individual landowner may seek prices above their genuine assessments, resulting in delay, additional expenses, and possibly failure to finish the project entirely. One economic study identifies the following three factors that give rise to the holdout problem. First, sequential bargaining between a buyer and multiple landowners. Second, commitment during the bargaining process, that is, all sales are final. And third, the reservation price of current landowners exceed the value of individual parcels to the buyer, so that partial assembly is inefficient. The sellers are able to demand higher price for their lands, which could potentially exceed the gross value of the entire project, as the developer commits to the project for which they are purchasing. At this stage, the government exercises its eminent domain powers to counteract the ability of the holdout to capture an unfair share of wealth, condemns the land in question or acquires that land and then transfers the title to the developer, who supposedly would put the land to better use, ostensibly of economic development. If the government does not forcefully seize property and use it for economic growth, a small number of holdout owners might either delay an essential project, or collect a prohibitively expensive price for acquiescence. There are two categories of holdout: strategic holdout, who refuse to sell in order to achieve a greater price and are economic holdouts, and sincere descendants, who actually value their land more than the developer does. Because acquiring property from true dissenters reduces the societal worth of the land, a desirable strategy would successfully defeat strategic holdouts while honoring the preferences of sincere dissenters. One commentator has argued that in cases of strategic holdouts, resorting to an eminent domain might be preferable, provided that the chances of a strategic holdout are substantial and highly likely. The transfer of land is made to a desirable owner, and no other method is likely to work. Two common methods of preventing strategic holdouts are: first, the secret purchase of land, and second, pre-commitment. The secret purchase of land, sometimes also called secret assembly, prevents holdout by denying the potential holdouts the knowledge of a large assembly projects. The secret assembly method attempts to solve the holdout problem by denying sellers information that there is a synergistic value that they can capture by holding out. The government is required to operate transparently and thus cannot resort to secret assembly. But there is nothing preventing a private entity, example a private corporation, from practicing this method. The Disney Corporation effectively employed this method in 1960s to secure land for the construction of Disney World in Orlando, Florida, and later in Virginia. Harvard University used the same method to acquire land in the Boston area. The pre-commitment strategy requires the developers to sign contract with all the owners in an area where they hope to build, under which they commit themselves to paying the same price to all, with perhaps variations stemming from differences in the size or market value of a particular property. Pre-commitment usually works better for those like the government who have to operate in public. India has also successfully tried this. As discussed, the holdout problem arises when an urban development project requires the assembly of a large number of small pockets of land owned by different people into a single large unit of land. One economic study argues that a project that requires the assembly of a large number of small pockets of land into one large unit is socially worthwhile only if its social benefit exceeds the sum of the value of the individual properties. It stands to reason, therefore, if the owners of these small pockets of land are willing to sell their land for prices that exceed the project's net benefit, there is not much economic logic in going ahead with such a project. Government intervention via the exercise of eminent domain powers after the failure of private developers to acquire these small pockets of land in order to create a single large unit of land for their project is bound to create considerable dissatisfaction in the minds of genuine dissenters. One study, therefore, suggests a self-assessment mechanism whereby the government, instead of acquiring private land at government assessed prices, requires every owner to state the price at which he would voluntarily sell his property. The government makes under assessment costly by requiring that the owner sell his property at the stated price, that is, the value at which he has insured his property. It makes over assessment costly by requiring that the owner pay a valuation tax on the price that he states the insurance premium. Now, concluding with the module, let us go back to where we started. Farmer Z's land can be acquired by the government and handed over to Corporation X because X has promised that the said land could be put to better use if its proposed project is implemented. The government is convinced that X's project is going to bring economic development to the area, and that is what they promised to the voters in the last elections. In this scenario, we see that there are several reasons why Z's land should not be acquired by the government and then handed over to X. It is more desirable to let X approach Farmer Z and make him an offer that he finds acceptable. If he does not, market mechanism have to be respected, and X will have to go elsewhere and find a community that will see the merit of X's ideas and sell their lands to them. If X's project succeeds, perhaps Farmer Z will realize the error of his ways and be more amenable to the next projects that X or some other private corporation presents for their consideration. In any case, respecting market mechanism for the effecting land transfers for private development projects would have the benefit of no litigation and no adverse public opinion. If the voters from that area complain that the government has not been able to deliver on its promise, the government can reason with their voters by pointing out that they had indeed convinced a private investor to come and initiate the project in that area, but the people saw it fit not to sell their lands to the investor. In the case of a strategic holdout, a member of that community, in this case Farmer Z, would be the one to blame, not the government. Furthermore, the government has several options to fulfill its promise, and it is incorrect to insist that the only way to bring economic development to our hypothetical community, of which Z is a member, is through private investors. There is no way the government can hold private company X responsible for failing to deliver on the promises they made to the government. What are the consequences of a Kello or Pole Town situation? The story of village Man near Pune is a close example. In an instructive case study, the researcher who studied the case of Man found it was a matter of great anger and frustration among villagers that, in spite of earlier promises, hardly any jobs had been given to them. One of the reasons was a lack of skilled labor, and another was the preference of private company to rely on migrant labor, since the local people were more demanding and prone to get into arguments. It is known that the private lands condemned in both of these cases lay vacant, and the communities never saw any economic development. Then there is a risk that private company X could fabricate a plan to persuade the government to purchase Farmer Z's land, only to subsequently seize that land, a situation known as rent seeking. The government can completely avoid this eventually if it chooses to remain out of the process and allow the markets to handle the transaction. With this, we come to the end of today's lecture. I hope the concepts of the holdout problem and its implication for the eminent domain are clear now. Thank you so much, everyone.